stating that the choice of the chairman, or as the case may be, the Speaker of the House, is not conclusive. Critically evaluating the benefits and drawbacks of anti-defection legislation. Anti-defection legislation has a number of advantages. Corruption. The law aims to avoid political defections that may be motivated by a desire to satisfy the political masters of power, as well as circumstances that function as a deterrent to political bribes. Political certainty. Because of the ongoing trend of coalition administrations, the defection of a few MPs might lead to the fall of a government due to personal malice and avarice. Party policy. If these candidates are elected, political decorum dictates that they follow the party's policies and promote the party's agenda, rather than siding with the opposition. Anti-defection laws have a number of drawbacks. The anti-defection law is blatantly anti-legislative freedom of speech and expression. The anti-defection statute infringes on this right by requiring all members to vote in precise accordance with party policy and to concur completely with party whips. This takes away a legislator's ability to vote according to his or her conscience. It also inhibits disagreement against the party's positions and policies, unless it is done through an all-party forum. Prohibition of dissent may jeopardize Parliament's ability to serve as an effective check on the administration. This might put the government's accountability in jeopardy. Legislators are no longer accountable to the people. Legislators can now say that they voted a certain way because their political party forced them to. Their rationale is frequently that they have little control over their vote, and hence should not be in command of it. After thoroughly analyzing the rationale, I can conclude from the case that voting dissent has long been regarded as a sign of political turbulence and lack of cohesion. Every political party, without a doubt, would appreciate steadfast support for the current mandate. The member's commitment to the party is demonstrated by the fact that he or she must follow the whip's directives. She could not, however, overlook the interests of his constituency in order to balance his or her interests. It is incorrect to consider such behavior to be disloyal to the party or to have a negative impact on the party's cohesion. Members of the same political party may openly hold conflicting views on a given issue, and expressing those views may result in the revision or withdrawal of proposals under consideration. Such a result can only be attained if members express objection. Intra-party dissent and dialogues, both necessary components of intra-party democracy, are contingent on the leader's willingness to allow members to express themselves. Judgment. The preponderance of the evidence speakers. Chairmen are the protectors of the House's rights and privileges, and they play an important role in parliamentary democracy. They are expected to, and do, make key decisions in a parliamentary democracy, because they have been given the power to decide questions under the 10th schedule. They should not be considered exceptional minority point of view. The Speaker's tenure as the authority to decide this disagreement under the 10th schedule is conditional on the House's ongoing support. Hence, he does not fit the qualification for such an independent adjudicatory power. It was also determined that paragraph 6 of the 10th schedule does not create a non-justiciable zone. The Speaker. Power chairmen to resolve disagreements can also be viewed as judicial. The Election Commission took a similar approach, based on the views of Justices L.M. Sharma and J.S. Verma. In 1977, it made recommendations and suggested that defection-related disqualifications be referred to the Election Commission for an opinion to be extended to the President or Governor, as the case may be, and that the President or Governor act on the Election Commission's similar opinion, as was the case with other disqualifications related to Articles 102 and 191 of the Constitution. To summarize, the Honorable Supreme Court maintained the constitutional legality of the anti-defection law in a 3.2 decision. The majority was made up of Justices M.N. Venkata Kalaya, K.J. Reddy, and S.C. Agrawal, while the minority was made up of Justices L.M. Sharma and J.S. Verma. Conclusion: dissenters are mostly in the minority within the confines of centralized political parties that are powerful enough to silence them through their whips. According to Kihoto, there is room in Schedule 10 to address the concerns of dissidents. However, a clearly delimited nurturing field within the purview of anti-defection measures must be provided in order to protect the talents for a functional democracy. The petitioners in Hollohan questioned whether it was fair for the Speaker to have such broad powers, considering the likelihood of bias.